Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Appeals Court, now sitting at Boston, within and for the Commonwealth, draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open. Please be seated.
Thank you, Gio. Good morning and welcome to the Massachusetts Appeals Court. My name is Judge Desmond. To my right is Judge Shin, and to my left is Judge Walsh. And we'll be your panel for all 5 cases that we have on our docket this morning. Just a couple of little ground rules for those who may be new here. Each side gets 15 minutes. There is no rebuttal. We are familiar with the cases and we're familiar with the facts, so you're welcome to just go right into your arguments. But of course, you can use your 15 minutes however you see fit. We'll probably listen to 3 cases and then we'll take a short recess for 10 or 15 minutes and then we'll come back and we'll hear the final 2 cases. The first case on our list is docket 25P 0380, Derek Walton versus David Walton. I understand that the lawyers want to split their time. Is that something that I'm hearing for the first time 2 minutes ago?
Your Honor, I did notify the clerk that we were splitting the time by issue. I will argue the will interpretation and no contest, and Mr. Sylvia would argue the promissory estoppel.
All right, that's a bit irregular without some advance notice to the court. So kindly let us know in advance the next time you're going to divvy up your time for one party.
I thought we had, Your Honor, but
I heard that somebody else was sitting. We got notice that you'd both be sitting here, but only one would be arguing.
I see. Okay. My apologies to the court.
No worries. Morning to you.
Good morning, Your Honors. My name is Lois Farmer. I represent Derek Walton, the appellant. I would like to, if I can, refer to the parties by their first names to make it a little easier to keep track of them.
Sure.
Okay.
They're brothers?
They're brothers.
Sorry to hear that.
Your Honor, a major part of this case is the no contest clause, and whether or not the actions of Derek Walton triggered the no contest clause, therefore stripping him of any rights to his mother's estate. But no contest clauses are not automatically applied in all circumstances. Equity and fairness must be adhered to and require that you hear any kinds of issues raised by the parties to the extent reasonable, I would assume. And it also doesn't apply, however, to certain specific actions, such as contract actions. So I would like to begin my argument by referring to the promissory estoppel action. I had supplied to you yesterday a 16L letter, which I also supplied to David's attorneys, and this is to introduce you to the case of Wittis. Wittis is very similar to this particular case, although the parties were not related. In Wittis, the person claiming a life estate was claiming it based on a holographic will written by his long-term life partner.
Let me ask you this question just at the outset. Do you think that the will is ambiguous?
I do. And there's multiple ways in which I find that the will is ambiguous. There's issues as to whether or not on Article 3 there was a actual devise of the real estate within Article 3. In Article 3 and in David's brief and the summary judgment, they relied for the idea of a conveyance of a tenancy in common on the language of Article 3. They didn't really closely identify Article 3, as where they would.
Why don't you point to the language that you say specifically you find ambiguous? Let's point to it.
The ambiguities is what was actually granted in Article 3. In Article 3, it says, I grant my sons the right to use and occupy the property. The property shall, basically, that's the main part of it. The word I grant my sons, does this convey a tenancy in common, which I have suggested to you it does not. And I have shown you that the ambiguity arises in part if you refer to the other two provisions around that particular Article 3. In Article 2, the testatrix said, I give and bequeath. That conveys, that devises.
So if it's ambiguous, shouldn't the disposition be to remand for an evidentiary hearing?
I would say it would.
Okay,
That would be the
because
result.
in your request for relief in your brief, you seem to be asking us to declare that your interpretation of that article is the right one.
Well, I think you can do that. There are cases, and I can't off the top of my head remember which one, but there was a case that said even though it's ambiguous, well, Hirschman. Hirschman said, well, this is ambiguous, but nevertheless, we can, based on the record, determine.
I thought the reason why the court ruled there without remanding is that the wife had relinquished her right, the right that was at issue. I thought that's why the court was able.
Hirschman was a very interesting case for this, especially on the issue of ambiguity. In the trial court, the court determined that there was no life estate. In the appeals court determined there was a life estate. In the Supreme Judicial Court, the grant of the property for as long as she wants was not a grant of a life estate, but especially because, as the SJC noted, what you have now is the conveyance of 5/1/5 tenancy in commons to the wife and the testator's 4 children. And the court determined in part that there was no life estate because it would grant then and convey to the wife something beyond what encompasses the whole estate. And so therefore, what is it? And the court went to more, well, this is more of a use and occupancy as long as the wife wants to be there. And so that is...
So the plain language seems to suggest that Mom was leaving this property to the sons, and they could live in the property if they elected to, or one could live in the property if he elected to. Whichever one chose to live in the property would carry the costs of the property. But if one of them wanted to sell, they would sell and they would split the proceeds. Would you?
That's within...
At bottom, would you say that's what...
That's within Article 3, but within Article 3, the question is whether or not that conveyed tenancy in common or something less, a life estate or use and occupancy. And if within Article 3 there was to be the follow-through on the sentences 3 through 5, then what you can only do under Article 3 is sell what you got. And if all you've got is a use and occupancy, you cannot sell the property in a fee simple absolute.
I understand. Leaving the labels aside for a moment, do you agree that Mom wanted to leave the property to the sons, where one could live there as long as they wanted to live there, or the other could live there as long as they wanted to live there, but if they wanted to sell, they had to split it?
In terms of living use and occupancy, I would agree with that.
So
But-
can we go back, because I'm troubled still by this argument, that the ambiguity that you want us to read into this document is that in some parts, the language is bequeath, and in other parts, it says grant. And that somehow creates some inconsistency about Mom's intent. So, as a matter of law, you would want us to say whenever there's a will and lawyers, as they do, change up the words a little bit. Give, grant, bequeath, hand over. That inherently causes, as a matter of law, an ambiguity such that now we have to remand and determine what exactly did Mom want. The ambiguity, I grant my sons. I don't see how that's ambiguous. I'm just putting it out there. I don't see how anyone could read that and not understand what that means.
But it's a grant my sons a right to use and occupy. She does not say, I grant my sons fee simple absolute. I do not grant, it does not say, I grant
Lay
my
people
sons.
speak that way? Do lay people speak that way?
Attorneys do.
I understand.
And that's what was written in there. And the mother in the previous will had said, I grant to my son the life estate. So.
Is the previous will of any moment here today?
No, other than showing that there was, that the story 2 years prior to the writing of this will was different.
Okay. So if we were, or potentially to disagree with that argument, that the will was ambiguous, and your claim is that Derek's filing in equity of the promise that he claims David made did not trigger the no contest provision of the will. Tell me why it doesn't.
Because, Your Honor, that is an agreement that was made between two brothers after the testatrix died, before they filed jointly the petition for informal probate. If you look at the Woodruss case, there was no contest issue there, but other than that, it tracks this case quite a bit. In the Woodruss case, you have, as I started to say, there was the holographic will that had a life estate that was of no import in the probate court because it was not a witnessed will. So then they had to decide, it was an intestate issue, and they had to decide, well, what is conveyed, and no life estate was conveyed. So the property itself was conveyed to the heirs at law. But then what happened is that the individual who had claimed the life estate through the holographic will, and the parties agreed, well, yeah, that's what was intended. The life estate had been intended for this, for you, to protect you, or a lifelong life partner, and so therefore we'll let you have your life estate. Several years later, as here, this was not an immediate thing, several years later, they brought an
For a
eviction
moment,
action.
Let me interrupt. You have 4 minutes left. And I've read this case several times, and I appreciate you attaching that. That was helpful so that we could then go from there and not relive all the facts of that case. Your case is different, isn't it, from the facts of this case? Your case, Derek got up there before the judge and said, this is what we want, an informal probate. And we have 3 years to challenge something, and nobody challenged the validity of the will, of Mom's will. But later, he files an equity claim saying, David promised me I could live there for life. Doesn't that, if successful, change the distribution that Mom intended? And doesn't that, if again, is an indirect challenge to the validity of the will?
I would suggest, Your Honor, that it's important to remember that this occurred before the filing of the petition, so that Derek, changed his position if he thought there was unjust enrichment. He filed the petition jointly for informal probate. The judge at the court and him and David had admitted, well, Derek didn't have to do that. He could have brought a claim for unjust enrichment as a personal representative at the time.
But he did more than that, right? So when I read the equity claim, and again, we're talking about equity, fairness, justice. He gets up before the judge and says, this is my mom's will. We're not challenging the validity of it. I'm a personal representative, and we're going to see this thing through. And in the equity complaint, he claims, granddaughter exerted undue influence. He claims something else that I'm forgetting right now. And then he claims that there was this promise, right, that David made. And it's not in writing, right?
It's not in writing, but I would suggest that it was partially performed. I would suggest that it
So,
was,
partially performed. Tell me how that theory, which generally has to do with people doing something.
Correct.
So not just living and breathing in a house, but partial performance is, I'm going to rent out your house and I won't charge you rent if you renovate the kitchen and bathroom and you can live there for 5 years. And you start working and doing something and improving, generally, the property and partially working on something. You can't just pull that back, right? Because I relied on that to my detriment. But what performance was there here? He was staying in mom's house. I don't see where the performance piece fits this analysis. Help me understand that.
if I may, and this again is kind of similar to Widdes, the partial performance was A, jointly filing the petition for informal probate. B, it was deciding not to bring the issue of undue influence, and more importantly, back there when the will was being probated, he would have had the opportunity to sell the house, to buy out the house at that time at a very low rate. And admittedly, the increase in value was astronomical because of COVID, but nevertheless, property values increased. He had to have known that he would have not had the opportunity to buy out at the rate that mother foresaw at that time, but it actually quadrupled what would be the financial burden on him to buy it. So that's another way. And he did remain on the property and took actions, and this is subject of discovery, I would suggest, because there has been no discovery on this. What did he do while he was there on the property? David conceded in his answer, I believe it was, that Derek had paid some of the expenses. There's no indication that David had paid anything. Also, I would like to remind you that both David and Derek had equal fiduciary obligations. Neither one brought deeds of distribution. Neither one of them addressed this unjust enrichment other than by this agreement. So I would suggest that all the multiple things put together would constitute sufficient reasonable reliance and the detriment to Derek if he had to buy out at quadruple the price to a windfall of David, who hadn't paid anything for the property.
So the interim clause kicks in if either party challenges the will. Is that fair to say?
I'm sorry, what clause?
Article 8.
Article 8.
Is that triggered when one party or either party moves to challenge the will?
According to the judge and according to David, and I would agree.
That calls for a yes or no. So,
Not always.
okay.
An ouster petition, a petition for instructions would not trigger it. We have a declaratory judgment, which is...
How about a petition for partition?
I believe that did. Number one, if there was no tenancy in common that was conveyed, then that is a change of character of the property, and so therefore that would not have appropriate. Had David, which he could have brought a petition for instructions, or had Derek, we wouldn't be here. There would be no contest clause triggered.
I see that's your time. Any other questions? I see that's your time. We'll have to leave it there.
Thank you.
Thank you.
Good morning, Your Honors. May it
Horan
please the
McLean.
Court. My name is Attorney Kathleen Horan-McLean, and I represent David Walton in this case. I will be arguing on two issues, the will interpretation and the no contest. Attorney Doug Sylvia will be arguing on the promissory estoppel, although there may be some intertwining, which I am able to answer.
Sure.
Your Honor,
So,
I'm sorry.
I'd ask you to pick up where your colleague left off,
On the
which is isn't the petition to partition a challenge of the will?
I would suggest not, Your Honor, and that
Not.
goes back to the wording of the will, that the will is not ambiguous. It conveyed a property interest to the two brothers as tenants in common. David attempted to follow the terms of the will, which was asking his brother, to buy him out, and he refused. The only option for David to do was to file a petition to partition in order to realize his interest. And as Your Honor is aware, property vest, at the point the will was allowed, the title vested in the tenants in common. And, I'm sorry.
So if we were to, I'm sorry, did I interrupt you? If we were to agree with Derek that the will is ambiguous, and it goes back, and then trier of fact finds, in fact, in favor of Derek on how to interpret Article 3, does that mean that David is now out of the will? I mean, it seems to me you're arguing that whoever's interpretation is wrong gets nothing under the will.
If they challenge the will, but David didn't challenge the will in a petition to partition.
Neither did Derek. There is a dispute over the meaning of Article 3. And what you seem to be arguing is that whoever's interpretation is wrong gets nothing under the will. And I don't see how that could be the case.
Your Honor, I would suggest that Derek's interpretation is unreasonable. And I would suggest that because there are a number of cases that specifically say that the right to sell a property in full is inconsistent with the rights of a life tenant.
If we find Derek's interpretation to be reasonable, does that mean the no contest clause is not triggered? I'm looking at Mazzola, which is a published case, right? I think from this SJC, and says, the short and complete answer is that in seeking an interpretation of the will, the plaintiff has not attacked or challenged the will or any part of it. Isn't that what he did here?
Well, what he did, you're talking about?
Derek.
What Derek did. Yes, I would agree with that case. Yes, either party could have done a request for interpretation of the will, and that would not have violated by the case law the no contest clause.
Why isn't that what he did by seeking a declaration about the meaning of Article 3?
He could have done that, but instead he sued his brother. And if you look at the no contest clause that's at issue in our case, it is extremely expansive, and it covers both actions directly and indirectly which challenge or oppose the will. We would suggest it's consistent with the cases of Sinnott, Copa.
Those are unpublished cases, right? Sinnott is unpublished.
They are some unpublished cases, Your
And in
Honor.
that, the nature of the claim was directly challenging the validity of the will. Here, you say he could have filed a complaint for instructions and not violated the no contest clause.
Yes, but he didn't.
What is the functional difference between filing a complaint for instructions versus filing a complaint for a declaration? I don't see the difference.
Your Honor, I would suggest there is a difference when I think it's exactly what Elizabeth Walton did not want to happen. The response was to sue a brother, and to sue a brother, and in your lawsuit, you're seeking to say that, to change the character of the property that was conveyed to you. It does turn on, I think it does go back to, is this will ambiguous? And I think you can, if you look at the terms of the will, Your Honor, we're supposed to give the plain meaning of what the testator used to give effect to the plain meaning.
Okay, so what's the plain meaning?
The plain meaning was that that she granted the property to her two sons. They had the right to occupy jointly. They had the right to share.
Or separately?
Or separately. They had the right to share expenses.
The article never says anything like, I grant the property to my sons. It just doesn't say that.
Well, but she does grant to the sons the right to sell the property and to also retain 50% of the proceeds.
I agree with that, but it says, I grant my sons the right to use and occupy the property. Okay, and then it says, whoever chooses to occupy the property is responsible for all expenses of maintaining the property, okay?
Yes.
And then it says, should neither choose to live in the home, all costs should be divided equally. And if one decides to sell, then the other has a right to buy out, et cetera. So why doesn't everything in this provision follow from, other than the first sentence about right to use and occupy, follow from the clause, should neither choose to live in the home?
Well, I mean, I think the right to sell the property is inconsistent with the conveyance of a life interest, or just a right to occupy for the rest of your life.
If you are correct that all this provision does is give them fee simple absolute interest in the property, what is the purpose of the first sentence? The right to use and occupy?
In layman's terms, Your Honor, and I know the court is aware that we don't need the traditional words to devise a property. I think the court needs to discern the testator's intent from the words used. The mom wanted to give both parties, both sons, the right to live at the property, but she also wanted them both.
She conveyed them ownership interest. They have the right to use it. I mean, they're owners, right? It seems to me to be completely meaningless, the first sentence, if in fact all she intended to do was give them fee simple absolute interest in the home.
I think she was trying to specify the rights and obligations if a brother did not sell the property. I think she presumed that if either party wanted to sell the property, that they would each get 50% of the proceeds. I think that that's clear, but she wanted to address the situation if both sides did not, if both sides did not want to sell the property, what were the rights and responsibilities? That's what I would suggest.
I mean, I think I'm having trouble because it seems like she could have said simply, I give and bequeath my property to my sons, period. And then should one of them decide to sell, the other has the option to buy out.
Yeah.
That would accomplish the purpose very simply if it's supposed to be what you say.
Yeah.
Right?
That is true, and there probably was a clearer way to say what she wanted to say, but I would suggest when we look at the wording, that it is clear because of the right of, to sell. It's in line with In re Freeman, which is a bankruptcy case, which the court found that the right to sell a property is inconsistent with a life estate. So, yes, there was probably more artful ways to say what she said, but I would suggest if the court is charged with determining the intent, would be our position is the testator's intent gleaned from that paragraph would be that the devise was of fee simple.
Can I just jump off for one moment on that very statement? And so, forgive me for a moment, but you both use, the intent of the testator. And both of you seem, while questioning the language about what does this really mean of what we could live there both together, separate, apart, those days are past, right? And it seems as if, at least at some point, each of you agreed that regardless of that first sentence, regardless of whether it's ambiguous and gives a life estate or tenancy in common, Mom wanted Derek and David each to own half of the house. And so I find it a little bit disconcerting that if we're supposed to follow that golden rule of making sure that in the end of the day, that if we can, make sure that the intent is followed of what Mom wanted. Two of you can agree to follow the language, imperfect perhaps as it is.
Your Honor, we would have agreed. We attempted. So, I mean, David...
I'm just saying today, I find it a little bit difficult to argue intent when it seems pretty clear at this point in time.
I can assure you that there were many attempts to resolve at many different junctures.
Never too late, counsel.
What's that? I'm sorry?
Never too late.
And we stand open to that, Your Honor, Your Honors. I do want to get into the no contest, Your Honor.
Unfortunately, that's your time.
Okay, thank you.
We'll have to hear from Attorney Sylvia.
If it pleases the court, I'm Douglas Edward Sylvia. I'm here representing David Walton in his opposition to the appeal of Derek Walton.
Let me ask you this question, Attorney Sylvia. If we think that the language, "I grant my sons, David and Derek, the right to use and occupy my property located at 21 Sunset Street, Mashpee," is not ambiguous, and David is the first one to move to partition the property,
Yes.
would you characterize that as a challenge to the will, and why wouldn't he then have triggered Article 8?
No, I don't believe it to be a challenge of the will because it's one of the clearest things in the will is the power of sale. And
But that's only triggered, it appears, if one of the sons elects not to live there, or if both sons elect not to live there.
I didn't interpret it that way, but that would create a life estate, but I don't think there's anything that says it's only for so long as they want to live there. There's none of that wording. There's no life estate wording of any shape or form in this, and there's no remainder
I grant
interest.
my sons the
Yes.
right to use and occupy the property. Said occupant or occupants will be responsible for necessary maintenance. So the fact that it's singular seems to suggest that she envisioned maybe only one son's going to live there.
Okay.
Okay? And so if he chooses to live there, then he has to carry the costs.
Sure.
So
But there's
what's
no for
ambiguous?
so long as he chooses to live there. Either son can then choose to sell. If either son chooses to exercise his power of sale,
Only if they both elect not to, only if one or both elect not to live there.
I don't see the wording that way, but that's not my interpretation of that wording. But I think that he had no choice. Like my sister said, he notified him, please buy me out. And there's no response, or ineffective response, so he filed a petition to partition. I don't think that violates the no contest clause. Now,
He
what
notified
Justice
him.
Shin said,
When did he notify him that he wanted to buy it? It was later, right?
well, it was, yes, before the filing of the, months before the partition. the
Okay,
petition,
but a few
not
years
not
after the
years, not
probating,
years,
right?
Not years. What you were getting in, I believe it's up to the court. It's up to the court to decide on the no contest clause whether his right to have an interpretation, if he can do it imperfectly. Can he do it imperfectly in the way he did it? Can it be that way? Copo Bianco, if you look at it, says there's a big difference between an equity claim attack against a trustee and a request for instructions, which the trusts kind of follow the will law. That's up to you. I mean, that's why we're here. That's up to you to decide whether his request is really a request for instructions, even though he just attacked and made all these allegations. Especially with
You would agree, though, that the no contest provision of wills are to be read narrowly.
Correct.
I mean, it's the nuclear option, right?
Correct.
And so it seems to me that there were two different arguments. One is by challenging whether it's a life estate or a tenancy in common, Derek, you lose. The second is by filing a case in equity, claiming undue influence and promissory estoppel, Derek, you lose, right?
Yeah, well, we were put in the position, what do we do? I mean, he attacks. He didn't file a request for instructions. We could have all joined in and got instructions. He didn't do it that way. He attacked. So when we attacked, we had no choice but to claim he violated the no contest clause.
It's hard for me to see how the promissory estoppel claim is challenging the contents of the will. Let's say Article 3 is crystal clear and supports your position.
Yes.
And so David has the absolute right to partition. Let's just assume that to be the
Yes.
case. But separately, he says to Derek, all right, I'm not going to seek to partition this property. You can stay for as long as you want, as long as you do X, Y, and Z. Why is that not a proper claim? I don't understand.
Well, remember, there's two claims. So I believe the stronger violating claim is the declaratory judgment claim. That's the stronger claim for violating the no contest clause. Now, we get to the promissory estoppel. That's a question for the court. Does it violate the no contest clause? The main problem with the promissory estoppel is he's depending on undue influence that it's out of time, beyond all statute of limitations.
That doesn't matter.
as
I mean,
his
I don't
reliance.
understand why statute of limitations matters. He's saying that because of this promise, he didn't do certain things back in 2018, whether it's file a claim for undue influence or whether it was not to seek to buy out the brother's share at the time when the property was worth much less than it is now.
Yes.
That goes to detrimental reliance, not
Okay.
whether the claim is valid.
Just look at the exceptions. Just remember, promissory estoppel in this case falls in the exceptions to the rule.
Which
That you're
exceptions?
allowed to rule upon a motion for summary judgment because of the exceptions in this promissory estoppel. The exceptions are contradiction, the contradiction with the written statement. So that's all in our brief. It's in a brief. It's the contradiction. So when you can rule on this normally you can't rule on a promissory estoppel. It needs to go to trial, but in this case, it's the exceptions that are the facts. And that's what overrides the Willis case also. It has nothing to do with it. The Willis has none of the exceptions to the promissory estoppel rule.
I see that's your time, Attorney Sylvia. The matter stands submitted. Thank you all.
Thank you.
Well argued on both sides. The next matter on our docket is 25P0136, Goncalves versus JACQUES-GONCALVES. Apologize if I mispronounced the name. You leave some documents? Attorney Cosentino?
Good morning. Yes, thank you.
Morning.
Good morning, Justices. My name is Michael Cosentino. I represent the appellant, Felicia Jacques. Although interesting, I will dispense with the facts and go to the two main issues of the case. One has to do with the inclusion of the triangular parcel in the disposition of the marital property.
And do you agree that motions to amend are to be granted liberally, as Judge Foster did?
I do not. I believe that...
What case do you look at that says that motions to amend are not to be granted liberally?
Well, I think the cases we cite in the brief, specifically the undue prejudice cases that we cite, and specifically the reason for that is that the divorce agreement was specifically negotiated. It only references the marital property. It doesn't reference the triangular parcel,
But doesn't it say we're here to resolve all and every issue related to the marriage? We want a clean cut going forward. Isn't that the general language of that agreement?
The property was acquired after the marriage.
I understand.
It wasn't even addressed in the divorce agreement.
Had it been acquired before the marriage had terminated, would it have been included?
I don't know. I wasn't a drafter of the documents. The parcel the triangular parcel is between two other pieces of land. It's a vacant piece of land. It had no value to either party. It only came up after the initial petition for partition was filed.
And that was by the Mitchells.
By the Mitchells, yes. The appellant decided, pursuant to the terms of the divorce agreement, to live in the property, okay? She paid the mortgage. She paid all the taxes. She paid everything for it.
That was all well within her right.
Well within her right, and when she exercised her right to buy the property, that's what she did. She took all steps necessary to obtain a mortgage for that property. After the court included the triangular parcel, which I believe was an error, it changed the equation because you had a appraisal that was done, which didn't parcel out what the triangular parcel was worth and what the house was worth. So you have a number that is well beyond what the appellant anticipated when she decided to exercise her right. It also conveys an unjust benefit upon the husband. If you don't mind, I'm going to refer to them as wife and husband.
Sure.
It's just a lot easier. It conveys an unfair benefit to the husband in this respect. It serves no value whatsoever, although it increases the price that she has to pay for the property.
It increases the value of the property, right? And then she has to buy out his 50% share.
It unintentionally increases the value of the property.
Okay.
It's a piece of property that has absolutely no use. If it had a use, I would argue that
it has no use standing alone, but it increases the value of the property, of which she's entitled to 50% of the final assessed value. So isn't she getting her money back?
No, she doesn't get her money back, especially how the court did the calculations, which is the second issue. She doesn't get her money back. This is a piece of property that if they wanted to exercise the right, they could have filed, the husband and wife could have filed a petition. They did not. Ms. Jacques was forced to defend a partition action of which the husband didn't participate in. It wasn't a voluntary act. It was an involuntary act because the parties were engaged in litigation. There was no reference to the triangular parcel in the divorce agreement. If either party could have put it in there, and they did not.
Didn't it also, I'm sorry,
Go ahead.
didn't it also not refer to 3 Cedar Park? It
I'm
only
sorry?
mentioned, didn't the agreement only mention 5 Cedar Park and not 3 Cedar Park?
Respectfully, Your Honor, I would argue that that was it was a drafting error that was done. The property is clearly a two-family piece of property. You would see that on the deed. You would see that in the record. It's just a drafting error. I would argue.
I mean, do you agree that the husband had the absolute right to seek to partition 5 Cedar Park, 3 Cedar Park, and the triangular parcel, and he could have filed 3 separate petitions, right?
I would argue, Your Honor, that the initial petition was only to petition the marital property that was governed by the divorce, that was covered by the divorce agreement.
Regardless of the agreement, he's entitled to file a petition to partition the triangular parcel, right?
Arguably, but he did not. The Mitchells
But
filed
he
it.
could have, not the rectangular parcel. After the Mitchells' action was concluded,
Yes.
so now the husband and wife own the triangular parcel together. He has the right to petition to partition that parcel, right?
I would say, Your Honor, he would have the right to do it. but
Okay,
you
so
have
let's
to look at-
let's say he did that. The judge, faced with separate petitions addressing more or less the same property, why doesn't it make just sense to consider it all together as one property?
Because they should be valued separately. They shouldn't be valued as a whole. First, he didn't do that. He was forced, he did it after the Mitchells filed a petition. The petition action was going on for many years before for at least a year before the amended petition was filed, okay? It changes the landscape of the case from the start. This is a person who was paying for one piece of property and was maintaining one piece of property, not 2. She wasn't getting any benefit from it then, and she's not getting any benefit from it now.
Can I just ask specifically, you agree that the standard of review is abuse of discretion, correct?
I do.
Okay. So that's a pretty high hurdle. And so what specifically did the judge do that you believe constitutes an abuse of discretion?
I think I don't know whether it was knowingly or unknowingly. I think he conveyed a unintentional benefit on the husband. That's what I think he did. And again, it goes against the specific language of the divorce agreement. And this is something that benefits him and it has no benefit to her. It's just if it was a trial court case, Your Honor, I would say, let's do a view, and you would see the property. All it does, it costs her more money to buy out something that has no benefit to her whatsoever, which goes to the second part of the argument. Do you mind if I move on to the second part of the which goes on to the second part of the argument, which is how the proceeds of a sale or the price of the buyout was constituted, okay? The judge, I think there's a specific error of law in that the judge failed to credit her properly for all the mortgage payments that she made, failed to credit her for the capital improvements, failed to credit her for all the fees and attorney's fees and costs that she incurred in defending the partition action. The specific language of the divorce agreement is that she gets reimbursed. The wife gets reimbursed. What should have happened is she should have gotten reimbursed at that time the $151,000. It's now a year later, so she's still paying all those mortgage payments. That should be reimbursed to her, as well as the capital improvements, as well as the difference in the attorney fees that she incurred in the partition action, as well as half of the fees with respect to the Mitchell action. She should have gotten that money. That should have been written to her out of the settlement when the sale is actually done, and then, and only then, does the number split. That's the main issue. I think the way the numbers were calculated, it again confers a benefit on the husband for everything that the wife did. It's not in line with the specific language of the divorce agreement. She should have been credited. If you're doing a real estate settlement sheet, for example, and you have someone who is advancing funds to make the house ready for sale, those get paid off the top. Those get paid to the person, and then proceeds get split. He does not get the benefit of her making all the mortgage payments. And the divorce agreement was specific. She didn't get credit for real estate taxes. She didn't get credit for interest. She didn't get credit for maintenance or utilities. No, she got credit. She was entitled to reimbursement for the mortgage payments and the capital improvements. If that wasn't the case, and what was the purpose of the evidentiary hearing itself? We could have just submitted the numbers instead of incurring the time and expense to go through those numbers and to present to the court everything that she did and discussing all the capital improvements that improved the property for eventual sale.
So what do you think her net loss is?
As we stand here today, I think in pages 24 and 26 of the appellate brief, we say that the split should be the husband should get $588,427.
So 90,000. What do you think the net loss is? What's the number?
I think that's the difference. The court had 679,004 versus our calculation of 588,427. And I think as part of the relief that we've sought, by sending it back to the court, I think the appraisal has to be redone, and the parcels have to be appraised separately. Unless there's any other questions, I have nothing further.
Hearing none, thank you very much.
Thank you.
Attorney Boehner? So what do you think?
John Benna for Armindo Gonzalez. Good morning.
Good morning.
We think that the trial court reached the most equitable resolution of a difficult problem, and that had the land court denied the original 15A motion to amend the complaint, the court would have immediately dealt with a separate complaint under Chapter 241 for separate partition of the triangular parcel. To do so would have confronted the land court with the same dilemma that they had under 15A, which would be how to advantageously and fairly divide the triangular parcel. Not combining it with the primary improved parcels would increase the dilemma for the land court as to how to partition that parcel. The objective indicators are that that triangular parcel is not a separately, independently marketable parcel. And clearly, based on its location, the way that it's been used historically was a vacant lot adjunct to the primary improved parcels, which was part of the marital home.
That parcel was part of a separate action that only the wife litigated. Is that fair to say?
Both the husband and wife were named in that triangular parcel case.
Who wrote the checks?
I'm sorry?
Who wrote the checks?
Mrs. Gonzalez did. Okay. Yes. However, the order of the court actually reimburses her for half of the costs that she incurred, consistent with the trial court's decision to amend the petition and include the triangular parcel.
So did she get that money off the top?
Under the judge's order, she does. The judge, in our view, scrupulously followed the contract procedure for distributing the proceeds. The offsets that were specifically included in the divorce contract were taken from the gross proceeds of sale, consistent with the language of the contract. The judge then looked at the abutter costs and the difference in counsel fees and did a separate calculation to separately subtract that from the divided proceeds. So from our point of view, the judge followed the contract very specifically, and the wife was fully reimbursed for her defense costs. The wife does get a benefit from partitioning both parcels. She has lived at this home for many years. It's immediately adjacent to her home. As I mentioned earlier, it's not realistic to think that it's marketable to a third party. If it were sold to a third party, she would now have someone occupying 2,400 square feet immediately adjacent to her residence. This parcel is above street level. It has no independent access to the street. The only access to the parcel is over the abutting properties.
Does it have any encumbrances?
I think that's an open question. The original deed from the City of Boston had a number of covenants appurtenant, which severely restricted the use. When the parties conveyed, the Mitchells and the Gonsalves conveyed, they attempted to extinguish those covenants. To my knowledge, whether those covenants have been extinguished, if they were tested, is probably an open question. But leaving aside the issue of whether the covenants continue to have an impact on the uses of that triangular parcel, the fact is that it is a severely limited parcel. In all probability not buildable. It's shaped as a triangle, it's above street level, and as I submitted before, not realistically marketable to a third party.
Don't feel compelled to have to use all of your time if you have nothing additionally to tell us.
I would just say, Your Honor, that we do not feel that the contract is ambiguous about its inclusion of the original rectangular parcel, which at the time of divorce, the parties did own jointly. The triangular parcel was derived from the rectangular parcel, and the rectangular parcel was owned. I think it's a reasonable reading of the contract to conclude that reference to the marital home, and as the bench has pointed out, an incomplete description of the address of 3 and 5 Cedar Park, given the limited utility of that particular parcel, it's understandable that the drafter did not include it by street address. But it's very clear in looking at the terms of the contract, as stated at the very outset of the contract, that the parties intended to resolve all of the issues resulting from their marriage, including all of their property rights. I have nothing further. Unless there are further questions, I'll rest on our brief.
Thank you kindly. The matter
Thank you,
stands
Your Honor.
submitted. Thank you. Next up is 24P1164, Melissa B. Steinberg versus Paul A. Steinberg. Attorney Zane.
Good morning, Justices. Juliana Zane on behalf of the appellant Paul Steinberg, and I have my colleague Richard Novich here with me.
Good morning.
Here, the trial court abused its discretion in the financial awards made to mother and the children. As a result, we view the judgment to be unconscionable. At its core, the issue is a math equation. The fixed financial awards equate to at least 41% of father's gross base income and more than 50% of his gross net income. As a result, it is impossible for father to meet his most basic needs, which the trial court credited on his Rule 401 financial statement. It is our position that there were 3 main abuses of discretion. The first, the fixed support obligations at 41% of the gross base income not only exceeded the mother's need as credited by the court and exceeded father's ability to pay, but also effectively rewrote the terms of the parties' bargained for divorce agreement by doubling father's fixed support amounts to mother from 22.5% to 41.5%. And as a result, mother receives more of father's net income than he does, which is inequitable.
And the original, what were the terms of the original agreement?
The terms of the original agreement regarding the support amounts made,
Was there a deviation upward or no?
there was. To the time of the modification judgment, yes, Your Honor, yes, Justice. At the time of the divorce agreement, the only fixed support obligation father agreed to was child support in the amount of $1,254 a week. The alimony and college provisions were based on variable income structured by caps, would only be paid if, as, and when that additional variable income was paid. The modification judgment fundamentally altered that structure by making the child support, alimony, and college expense fixed. Then, in addition to those 3 fixed categories of expenses, which total $2,477 a week as opposed to $1,254 a week, there are additional percentages paid on variable income for additional alimony. And it's our position that that vastly exceeds mother's need based on the documents, the financial statements that the court credited.
So in the original agreement, the upward deviation was, what was the percentage, 15%?
So it doesn't appear from the separation agreement that the parties followed the child support guideline application. I can't tell you what the upward deviation percentage was, although I do acknowledge that what was paid was not the presumptive guideline amount at that time.
It was more than that.
It was more. I believe the child support guidelines at that time utilized combined parental income of $250,000 a year, and the parties agreed to use father's full base of $290,000 a year in computing that presumptive guideline amount at the time. So the calculation that they reached based on father's base income back in 2019 was that about $1,200 a week child support figure.
What prevented the judge from changing the alimony structure?
So I think there's a few reasons. The first is under the Berkume case, it is the judge must consider the intent of the parties in drafting.
Yeah, it says, to the extent possible and consistent with common sense and justice.
Right.
So it's not a bar on modifying the structure. And in that case, although in the agreement the wife had waived all alimony forever, the court still didn't say that the judge lacked authority to award alimony, but remanded for the judge to consider whether it would be consistent with common sense and justice. So how did the judge here run afoul of that principle?
So the trial court ran afoul of that principle first and foremost because the alimony award far exceeds mother's need that was credited by the court. So what the trial judge did in looking at the Rule 401 financial statement was she took mother's stated expenses and she chopped them quite considerably given the variations she was making and what mother would be responsible for under the judgment.
Needs are to be measured in terms of the marital lifestyle, right?
Where possible, that is correct. Needs are to be measured by the marital lifestyle. I think one of the fundamental issues we have with the judgment here is there are no findings whatsoever regarding the marital lifestyle. While the judge says she credits both parties' views of the marital lifestyle in the affidavits that were submitted in lieu of testimony, the judgment is otherwise devoid of any finding regarding the marital lifestyle.
Right, well, then at most you'd be entitled to a remand for findings on that, right? As far as the issue of whether the award exceeds the mother's needs, how can we decide on the record before us that it does?
So I think you can make the determination that the award exceeds the mother's needs if you look at, and this is
measured in terms of the marital lifestyle.
So if you're looking at the marital lifestyle, you'd be guided by that April 2019 financial statement, which sets the mother's needs at some $5,000 a week. The issue there is twofold. First, it includes expenses for the party's daughter that was emancipated at the time of the modification trial, so it would be inappropriate to include any portion of the expenses for that unemancipated child. Second, there were expenses included on that divorce financial statement regarding the upkeep of the marital home, which was sold as part of the separation agreement, thereby considerably reducing those expenses. And there were also categories of undefined expenses such as cash. And then fourth, there were expenses that were family expenses such as a cell phone plan, etc. And she is not incurring any portion of the expenses for father.
Sounds like you're asking us to make numerous findings of fact that the judge didn't make.
So we're asking you to reverse and remand the issue for the calculation of father support obligations, not only as to alimony, but also the 15% upward deviation in the child support guidelines. And in terms of being able to capture from the record before you how this exceeds mother's needs, the numbers are spelled out in the brief. We go through exactly what the court credited her expenses to be and what the financial award is. Just on the fixed financial obligations, she has a windfall of $25,000 a year. If you then include the 100% of what she could have received from the variable income, she has a windfall of over $100,000 a year just from the math laid out in the judgment and looking at her Rule 401 financial statement. So I do think that the court can make the findings that the support awards here exceed her needs by an extraordinary amount just based on the record before you. In terms of the second abuse of discretion, there was no material and substantial change to warrant a 15% upward deviation in the child support guidelines. Best I can tell from a review of the judgment, the bases for the judge's conclusion that a 15% upward deviation was appropriate is because father's parenting time was far less than 1/3 of the total parenting time.
Why isn't the mother correct that this is a modification of an existing agreed-upon deviation?
I don't think so, Your Honor, because first and foremost, you can't tell from the record before us, whether it's the separation agreement, the judgment, or the findings, what the deviation was at the time of the divorce. That would be speculative.
There was a deviation, right? So the judge doesn't have to make new findings about whether deviation is appropriate because it's undisputed that the father had far less parenting time even at the time of the divorce, right?
So I think I can answer that. It's sort of a two-part question in my mind. The first goes to exactly what Your Honor just said. He did have far less than 1/3 of the parenting time at the time of divorce. So that's not a change in circumstance. To now say in the judgment, and the judge is very clear, she goes through the structure for almost a page in her judgment of the percentages of parenting time each of them have had over the course of, I think, 3 years, and comes to the conclusion that because of that division of the parenting time, she finds that an upward deviation in child support is warranted at the 15% mark. Our point is that is not a change in circumstance. Nobody disputed, not mother and not father.
Less parenting time at the time of modification than he did at the time of divorce.
Yes, but that is not the standard. The standard is whether or not you have at least 1/3 of the parenting time, and then the second tranche is 50-50 parenting time when you're looking at the guidelines. Those are the
But
two.
you don't dispute that while he did have far less parenting time before he moved to Florida, he even has increased less parenting time now that he has moved to Florida. Or do you dispute that?
I do not dispute that, with the caveat that there were multiple additional requests for parenting time that our client made, and mother refused to grant him that parenting time. So if you would add back in the days he could have had pursuant to his requests that she denied, you're up. I agree with you. You are still less than what it was at the time of the divorce, but that is my point. There is no change. He didn't have 1/3 of the parenting time then. He doesn't have 1/3 of the parenting time now. And to the second part of Your Honor's question, the trial court actually was required, based on the guidelines, to make findings for deviating in this judgment at issue. And her findings and judgment did not include the child support order that would result from an application of the guidelines, which is step 1. It's nowhere in the judgment or the findings. It did not explain how that resulting order, the presumptive child support order, would be inappropriate under the circumstances. And it did not include specifics as to how the upward deviation was in the children's best interest. So there are a variety of findings the trial court was required to make, even in a modification proceeding, to warrant a deviation.
When you challenge the alimony award, you say the judge is supposed to take into account the parties' previously expressed intentions, and then in the challenging the child support order, it seems you're saying the judge should ignore the fact that the agreement already contemplates an upward deviation from the child support guidelines.
So standing on its own, I'm not challenging that. If she was mirroring the intent of the original agreement that there was a fixed deviation and then she was applying that deviation now, I don't have a problem with that. The issue is in the totality of the circumstances of looking at the combined support order. You can't look at one without the other. And that is part and parcel the problem that we have with this judgment. Plus, if she would have spelled out the findings of what the guidelines would have been, the presumptive guidelines would have been, why she deviated, how that was in the children's best interest, she would have overcome the hurdle of what is required by the guidelines. The third part of the issue with this child support deviation is she only looked at one factor in determining a deviation was appropriate, which is this 1/3 parenting time issue, but the trial court didn't give consideration to a myriad of other factors that could have warranted a downward deviation, which would have included at least father's payments towards college, his greater contributions to extracurricular and uninsured medical expenses, and the expenses that he incurs to travel to see his children, all of which the court credited. So it seems some things were taken into account and some things were not taken into account. And that is the overarching issue that we have with the 15% upward deviation in the guidelines. The third issue here is that beyond the third abuse of discretion, rather, is that beyond the fixed alimony order, the trial court also included an additional percentage-based variable component, which further exceeds mother's needs, even over the base support amount that already exceeded her needs. And it also includes an impermissible self-modifying order under the Young case. So here, the trial court seemingly relies on the variable nature of father's income to justify a percentage-based award. But that is contrary to what Young provides, which is that variable income in and of itself does not present the required special circumstances to put a percentage-based order into effect. It needs to be tied to the marital lifestyle, and most importantly, it ignores the bargained for cap that the parties put in place on father's income to determine the tranches of when mother would receive which type of support. It seems that, using the Berkume language, the judge essentially used this as a tabula rasa to rewrite the entire agreement, and the issue, first and foremost, is that the percentage of what we're talking about with the combined order, when you put this into practice, the real-world implications that this will have on a W-2 employee who doesn't get the type of bonus compensation to make this up, is that these are both non-taxable awards here. It's not as if dad can now deduct this alimony from his total support package and recoup that loss over and above the support order made and exceeding mom's needs.
I see that your time, Attorney Zane. Anything additional? Very well argued.
Thank you so
kindly.
much.
Attorney Kaur.
Good morning, Justices. My name is Kevin Kaur. I represent Melissa Steinberg, who made the trip to see these arguments today. It is a rare and remarkable occurrence for a probate and family court judge with the experience that Justice Jennifer Allen had to state without reservation and conclusively that to apply Kavanaugh's Step 2 leaves this family, leaves this mother woefully unsupported, undersupported.
Do you think if we had had a bit more of a robust discussion, we might have a better idea of exactly what was happening to reach the conclusions that the court reached below?
The noise in the background, I didn't hear the last thing you said, Your Honor.
Do you think that we're left to kind of fill in some of the gaps with respect to how the court reached or why the court reached certain conclusions?
Well, I disagree with Attorney Zane. I think the judge, in her rationale and her discussion, as well as her conclusions of law, she walked through entirely, completely, what her intentions were, why she did what she did. In the backdrop, Your Honor, Judge Allen had in mind and intentionally was responsive to the fact that the husband's chronic unavailability, his disappearance, overburdened this mother and frankly left these children unsupported for an extensive period of time. The outcome that Judge Allen specified would be woefully inadequate is exactly what Mr. Steinberg is asking this court, or suggests to this court, should be appropriate. It was the effect of the original agreement, child support only, with a prohibition, according to him, of any alimony on salary, and only alimony between $290 and $465 if he made it. So effectively, there was no alimony in the original arrangement. Now, Kavanaugh was decided after 2019. Kavanaugh 2 was decided after, frankly, the brief was filed in this case. And what husband is asking this court, or suggests to this court would be the appropriate outcome, is exactly the mistake that this court, the appeals court, identified in Kavanaugh 2. Kavanaugh 2 and other cases that have come down since then all stand for the proposition that child support cannot be considered when a judge looks at the circumstances to determine whether or not there's a need for alimony. The two must be analyzed separately. In this case, the overarching keystone, if you want to call it that, to the husband's appeal is the repeated statement that the $1,210 per week exceeds the wife's need. It does not. And I'll find my notes here on this.
Take your time.
First of all, and Your Honor has pointed out or asked questions concerning, the need has to be measured in relation to the marital lifestyle. Judge Allen stated right in her findings, and frankly, well, let me back up 1 minute. Judge Allen approved, I don't want to call it a unique, but an unusual procedure for these parties. These parties decided to try their case on paper. And as a result, they were allowed, the procedure was, each submits an affidavit, each submits a rebuttal affidavit, each puts together the evidence that they think the judge should consider. The judge stated unequivocally that she considered all of that affidavit testimony, you want to call it that, which included, with pictures and with descriptions and with costs, what this marital lifestyle looked like.
Considered and credited all affidavits, right?
Exactly. And the judge credited the financial statements from then, and my sister pointed out that the needs stated then were some $5,000 per month, per week, I should say, which comes to $275,000. And it was based on historical earnings that Mr. Steinberg doesn't want the court to consider and think about. $736,000 was the highest point the judge said this family earned, but the evidence and in the affidavits shows, and I apologize, dry mouth, that historically this gentleman's income, this family's income while they were married, was in the $600,000, $700,000, $800,000 range.
Sure. Did he have a significant change in employment?
He had a change of employment. He's had multiple changes of employment, which does dovetail into the question of whether or not this was one of those special circumstances for a percentage share.
Do any of the changes in employment equate to the earnings that he had with his initial job at, I forget the name of the company?
I guess it's a timing issue, Your Honor, because each of the jobs that he took after the nanostring job, they were comparable in terms of salary, and they were comparable in terms of the expectation of additional income, bonus income, commission income, and they were all comparable in terms of the presentation or the grant of these equity-type compensation arrangements, stock options in particular, which is what produced during the marriage these higher levels of income.
How did they differ?
Excuse me?
So how did they differ?
I just didn't hear you.
How did they differ? If you say they were all comparable, you're saying there was no change in the employment status?
Well, each time he changed jobs, he gave up the package that he had been granted in the prior job. And in the current job, he has, I think it's 140,000 stock options of the company. Now, those stock options have value, but they don't have value until the future. So as a result of it not being a publicly traded company, only this husband, only this father is the one who stands to gain that windfall, the potential payout in the future after his children have aged out and probably well into the alimony duration term. But I want to go back to the question you asked, the question of need. The Smith case, also decided recently by this court,
The what case? Smith.
made
Oh,
the
Smith.
made the observation of something that is a common occurrence in these types of cases. You have a situation where at the divorce and at the time in the marriage, they had certain expectations, certain lifestyle expenditures and so forth and so on, which are reflected and Judge Allen credited. Since the divorce, and when the father has essentially left for a different life in Florida, leaving his children, leaving his wife here to go from the marital home, which is in the evidence, to this little apartment in Natick, because the child went to school in Natick and she had to find something in Natick. That's all she could find. So as a result of being, as Judge Allen says, woefully under-supported, she ends up having expenses which are lower. Not because she's lowered them or wanted to lower them, it's because she didn't have the support she needed to live the lifestyle that they lived during the marriage. And in the Smith's case,
where in the judge's decision does she make any findings about the mother's needs relative to the marital lifestyle?
well, I was getting to that, Your Honor,
okay.
and thank you for reminding me. Judge Allen credited both sides' financial statements, both at the time of the divorce and now. If you look at, so the argument is, and again, the keystone is, if 1,210 exceeds need, well, it's not sustainable. But if you look at her financial statement, the 2023 financial statement, trial financial statement, she has net weekly income available of $538 after taxes and after retirement and other withholdings, against expenses of $3,161, which were credited. That is a deficiency of the deficit, I should say, of some $2,600. Now, even when you back out the things that Judge Allen identified as related to the children or maybe overstated because the husband has a share, that 629, she still has a deficit over that 538 of 1,993. Those are her needs on the reduced basis. So when Judge Allen properly and correctly applied Kavanaugh and looked at alimony independent of child support, which the law requires, she entered a judgment for $1,210 per week. That does not meet, I should say, the need. It's not an excessive need.
So
It actually
do
doesn't.
you think there's enough here for us to affirm rather than remand for further explanation? Because, you know, the parties have thrown a lot of math at us, which is unfortunate. Are we supposed to make those mathematical findings ourselves?
No, Your Honor, but I would like to, I think it's important that we look at, I think the term real world was used. If we look at how this judgment operates, I will submit and I'll suggest that if you do the math like I've done the math, and you can do the math from the appendix and from the briefs, if, like he did in 2024, the husband has $407,000 of income, because his bonus income is actually included in that. It's not just the salary, which is what he wants to focus on. He has a history of bonus income of $50,000, $60,000, $40,000. That's in the records. Melissa has an income of $151,000. Now, when you use that actual real-world income level of $407,000, the total support under the judge's structure calculates to $116,000. So she ends up, Melissa, with $167,000. Father ends up with $290,000 before paying taxes. Now, the judge did indicate that she looked at the tax issues. She challenged some of the marginal rates Mr. Steinberg submitted, and she said the actual rate is more like 26%. So when you take that you take that $290,000 and you calculate it in reference to the deductions and the $24,000 or so that Mr. would put away into retirement savings every year, you end up with a tax of about $92,000. So from that $290,000, you get down to $198,000 of leftover money after tax. That $198,000 more than meets the need that Mr. Steinberg put on his financial statement, which included all sorts of things that actually aren't current expenses, such as college being paid. So all of his needs, all of the needs he complains he can't meet, when you do the math on the $407,000, he ends up having a $550 per week surplus. And I could actually lay that out and submit that to the court and I can point to the reference in the appendix of how those numbers are calculated. But the reality is this experienced judge weighed all the evidence, weighed all the law. Her conclusion suggests she had all the points of law in mind, and she had the facts in mind of the lack of support in terms of parenting and so forth, and she reaches a structure. And the structure is, frankly, functions perfectly in terms of just getting the wife, the mother, to the point with alimony and child support of being able to meet her expenses and break even, maybe have $100 extra, while the husband's side, after taxes, he ends up with having a $550 per week excess. I mentioned the bonus income. Mr. Steinberg throws a bunch of tables and analyses and so forth in. All of them are based upon his lowest possible earnings, and he doesn't factor in what the judge did. This is a case where the history is bonus income. It's all in the evidence. This is a case with a history of stock options, maturing, ripening, investing, and producing additional income, all in Mr. Steinberg's column. So when you look at the structure that Judge Allen put in place, she decided that step one of Kavanaugh is the one that must apply. She properly determined the alimony. The alimony does not exceed the need. She then took those post-alimony incomes and ran the guidelines, and she ran them properly. Nobody says she didn't do it correctly. The question has come up as to whether or not this 15% deviation is justified or warranted or sufficiently supported by the evidence. Well, I think one of the justices asked, what was the deviation at the time of the divorce, and why was it? It very much was, and I think the brief even acknowledges, it was because he expected to have far less than 1/3. That became even more pronounced during the course of the post-divorce life, and Judge Allen makes findings on that. But what Judge Allen did, and I think Your Honor, Justice Shin pointed out, that this was not a new deviation based upon circumstances that changed after the divorce. This was the judge recognizing that the reason for the deviation has become only more pronounced. And she deviated, but only 15%, when the original deviation, it's in my brief, was 20% plus. When you run Judge Allen's structure against the highest levels of income that she anticipated, $736,000, the total support calculated, alimony and child support, to the mother, to the wife, comes to about $140,150. That does not approach the need that's reflected in the 2019 financial statements. It doesn't even come close. So to stand here and suggest that the judge's order, even at the highest levels, is going to give mother a windfall that exceeds her need, it's just wrong. The material change, I addressed this on my brief. There's so many different factors. The judge in her rationale laid them all out. The nanostring situation in particular, there was an expectation there that both parties had of both property and income from those options, and they were lost. To stand here and suggest after Mr. Steinberg himself filed a modification complaint because of that there was no change, it's just inaccurate. And in terms of following the intent or the structure originally set in place by this party's agreement, it's interesting that he says the judge didn't do it and the mother doesn't want to do it. When his own proposed judgment, it's at page, I think, 70 of the Record Appendix 2, he's seeking, or he sought at the time of the modification trial, substantial changes to what had been the existing structure. I submit that the judge, Judge Allen, followed, I apologize.
I see that your time, Attorney Corr. I think we understand. Matter stands submitted.
Thank you so much.
Thank you. Court will take a short recess. So next up on our list is 24P 1273. Is it CELATA? Is that how you pronounce it?
CELATA versus CELATA. Your
CELATA versus CELATA. John versus Andrew. Attorney Farrow?
Farrow, F-A-R-O. I think I've been before you before, a couple of years ago, maybe. Yes, maybe. Okay, may I proceed, Your Honor?
You may.
Yes, may it please the court. My name is Christine Ann Farrow, and I represent the appellant, John CELATA, who's seated in the courtroom today, Your Honors. The issue that's before this court is where the child should attend school, and in doing so, should there be a change of a parenting schedule. Until the lower court made its decision, it was a 2-2-5 parenting plan, but at the time the lower court made its judgment of divorce nisi, there was no indication as to where the child was to go to school. The court should review the court's conclusions and judgment. The lower court should be overturned, decision should be overturned if there's findings of facts that were clearly erroneous, whether there are errors of law, and whether the court's decision was not based on sound discretion but a whimsy. The appellee has entirely relied upon the Pierce case and has foregone any illegal analysis in its brief. And even though they've used the Pierce case, the Pierce case is really a child support and alimony case. This case is more akin with Cali, custody Zia, Prevenu, Pranabanu, and EK versus EK.
So can I ask you a question? You agree that the standard for review is abuse of discretion, correct?
It is an abuse of discretion, Your Honor.
And so when we look at the findings of fact that you claim are clearly erroneous.
Yes.
And they range from the claim about whether mother was working mother's hours or particular hours, and up to father couldn't decide which school, but the school was redistricting, so nobody would know exactly where the child would go to school. But even if they were all a little off, those ones that you claim, even if they were not exactly as the testimony was, where is the abuse of discretion when the judge has to pick a school, right? The child cannot go to one school for 2 days a week and another school for 3 days a week. And the judge made findings that at the end of the day, there was going to be a winner and a loser, right?
Correct.
So where's the abuse of discretion?
I think the abuse of discretion is, in Your Honor, when the court has set forth the precedent that a parent's steady employment and use of safe development and developmentally appropriate child care should not undermine the child's best interest. We had a working father here, Your Honor. In the court, you have to look at the facts de novo. You have to look at the facts entirely in this case. And it's clear that if the court finds that after looking at all of the facts of this case, and it's under the Embry case that was decided by this court recently, the upper court, that if there's been a mistake made, okay, then there's an erroneous error of fact. But what this court did, is it rests its judgment on the parent who worked fewer hours as being categorically better able to parent during the school week. And this is an illegal error, and this flies in the face of role versus role. And the court's findings expressly elevate mother's 11.1-hour work schedule. She worked 11.51 hours a week and 5-hour commute over all the overacting as a tiebreaker in determining what was the best interest of the child. And that really was the abuse of discretion in this case. When you look at all the overall factors in this case of how we got here. Okay, in custody of Zia, this court, which cites Kelly, this court cautions against rearranging a child's living schedule arrangements in an attempt to achieve some optimum. And what this court was trying to do, what the lower court was trying to do, is put a square peg into a round hole. And you can't meddle with the arrangements. This child for 3 years, okay, this child for 3 years was going to school in Gloucester.
Did mom get a vote on the child going to school in Gloucester?
Yes, she had. She was the one that pressed the child to be in daycare, and I asked the court to look at Judge Elwick's.
Did mom get a vote on the school that the child was going to in Gloucester?
Yes, she acquiesced under, and you could look at the Wooters versus the Keto case.
She acquiesced.
Your Honor.
She informed before the
Yes.
school was selected.
Yes, if you look at Judge Elwick, and Judge Elwick ruled the father was not in contempt, mother was fully informed, and there was no violation of mother's legal custody in ruling this. And the lower court completely overlooked that. The judgment of contempt was never, ever appealed by Ms. CELATA in this case.
But can I interrupt and just
Different
take it down a notch? First of all, the issue of whether your client was found in contempt is different in so many ways than the question that was asked, right? But the fact of the matter is when a child is 2 or 3 and needs a caretaker, a daycare provider, during that parent's time, when it's 2, 5, 5, that's a very different consideration to when the child now has to attend school and attend one school.
Correct.
Whether parents live an hour apart. Right? And so just because the child was in daycare
And preschool.
while the parent was working doesn't automatically mean, okay, now child school, formative years, have to go to that parent, right? I mean, this was in lieu of, because father was working full-time and had to have somebody care for his child during his appropriately scheduled time to be with child, right?
No, I think, I look at the court is that mother insisted that the child be in daycare, which transferred into preschool, Your Honor. And mother and father was involved in this child's daycare and preschool for 3 years. And when the court made and for 3 years, he volunteered at the school. He did the homework with the school, with the child every day. He took this child to school every day. But what the court did is, Your Honor, what the court did was prejudicial to the working parent, okay? The father had a track record going into the trial. He had a proven track record that he could work full-time and care for this child while this child attended school full-time during his days. And what the court did...
Let me interrupt for a moment. Unusual case in the sense of you have 2 parents who care for their child, love their child, and are involved in different aspects of the child's growth and development. And so at the end, because the parents could not agree upon what school that the child was going to go to, the judge has to assess.
Right, and he did assess.
And so there's no negativity attached to father's parenting skills or bonding. It's more that day, the judge needed to make a determination as to where child would be attending school.
And what he did is, he took a father for 3 years, did it all, marginalized his role as a parent, and entered a very, very prejudicial decision in limiting his parenting time and basically saying anything that you did in the last 3 years doesn't matter, and the child's going to go here. And what this court is doing, and I think this is a very, very important point, what this court is doing is, if they uphold the lower court's judgment, they're setting forth a precedent. They're setting forth a precedent that if a mother doesn't work, she's going to get custody of her kid. Wherefore, we have the working parent, okay, who's had joint physical custody of this child, has done everything he was required to do, worked full-time, took the child to school every day, picked the child up. There's no findings that there's any harm to the child that you would look for under EK versus SC, okay? But what the court is saying now is, okay, if you want custody of your child and your child to go full-time in your school district, don't work. And that's what's happened here. Now what has happened is mother, who only works 11.1 hours, She had the ability to do what Father's doing right now. Because she doesn't work, she's got the ability to come to Gloucester on Wednesdays and visit the child and take the child to dinner. She's got the ability to come to Gloucester on Fridays and pick the child up for school. Now what we have is an order that Father, who's working, the burden of transportation and everything that was included in that lower court judgment is put on him to the point now all extracurricular activities have to take place in Amesbury. So what happens? Father picks up child on Friday, takes the child home to Gloucester, drives the child back to Amesbury on Saturday, takes the child back home to Gloucester, then the mother picks up on Sundays. That's the current arrangement. So what the court did is, because the father works full-time, they basically took his rights away, or
So I'm going to interrupt you for a minute.
Absolutely.
Because I think we understand that the crux of your argument, you feel, is the disparate treatment for the working parent versus the non-working parent.
And the precedent that it was set forth before this court, going forward.
But the judge said that notwithstanding mom would be available if the child had some problems during the school day, she might be more readily available to respond to the child versus a third party who might be taking care of the child. But she went on to say, other factors that the court finds compelling include the fact that mother keeps father informed about Aviana and father does not. Father has elected to engage in the bare minimum of communication with mother while signing up Aviana for numerous activities in Gloucester without any meaningful communication with mother. Failing to communicate or to effectively communicate is not in the child's best interest. What do you say in response to that?
My response is I believe there's another finding in there that the judge makes that says neither party communicated. In both parties, and I think if the court looks at the evidence as a whole, you will find that mother had the child involved in many activities up in Amesbury during her parenting time and didn't inform father. So this was kind of like they both did it. And
I didn't see those emails in the record. I saw some emails in the record where it seemed like the communication was a little bit challenging when mom was asking father, but I didn't see those going the other way.
There are emails in the record.
Can you point me to them? Maybe just one or two.
I think you're going to find them in it's in my brief, Your Honor. I cite the emails in my brief, Your Honor. I think what is important, Your Honor, is that father, during this whole period of time, mother who insisted upon the child being in daycare never stepped foot in the daycare. She never went to any event that the child had during her parenting time at the school, such as a Halloween party or a Valentine's Day party. Mother did not take her. Father took child to everything. Mother remained uninvolved during this period of time. And I think what the court has to do, it has to look at the facts on the whole. And it has to look at what happened since the beginning of the judgment of divorce nisi to the date of trial, which was last year, in May of 2023. I think what the court needs to find, Your Honor, is the mother's efforts to undermine father's role as a parent, and you see that under the case about how she was constantly saying, we need to change the parenting time. We need to go to full custody. How many times she asked him to take the child out of the school. She asked doctors to write letters. When father enrolled the child in the YMCA. She called the YMCA and interfered with the membership. There were numerous doctor's visits regarding retroprolapses through January of 2030, January 30th, 2023, that took place during mother's parenting time, that never took place during father's parenting time. And when I finally pointed out to her predecessor counsel, saying, these things don't happen during my client's parenting time, they only occur during your client's parenting time, they stopped. Mother had did everything to undermine father's efforts, his role as a parent, and consistently asked that the child be taken care of out of the school after she insisted upon it, and that the custody be changed. I thank the court for its time. I ask the court to look at all the evidence in its entirety, and thank you very much, and have a nice weekend.
Thank you kindly.
May I approach, Your Honor?
You may.
Let me clean up my mess. Thank you.
Attorney Mateus?
Good morning, Your Honors. John Matus for the appellee, the mother. Just to quickly go over a few points that I heard opposing counsel raise in her oral argument. First, she cites to a case Roll v. Roll. I don't believe that was in her brief, and so I diligently tried to search for it. However, that was at the beginning, and she moved on to other cases. There's a number of others. Your question, Justice Desmond, as to whether the mother had input on the preschool, I would point this court directly to findings of facts 89, 90, and 91, where the court makes a specific finding, and this is on the first volume. I'm sorry. The first appendix in page 109, but 89 through 90. Father did not consult with mother before deciding on the preschool, did not include mother on the tour. Mother did not agree on the preschool, but it was during father's parenting time and necessary as a form of daycare while the father worked. Mother pursued a contempt action as a result of this. So the mother had no input on that, but she didn't have control over that because it was obviously during the father's parenting time when he was working. Let's see if there's anything else I wanted to quickly. And I would also point out, Your Honor, I know that this is being couched in the light of this is a punishment to the father. It is not. It is in the best interest of the child. And the court actually is very explicit in that because this first of all, it says this is not a change in legal custody. We're not finding that the father has done anything wrong here. But the second thing that the court says is the moment the school year ends, we go right back to the old parenting schedule, 2255. And in fact, not only that, during vacations and holiday schedules. So this is not a permanent thing throughout the entire year. And yes, and so moving forward, the three phrases that I think summarize this case are best interests of the child, material change in circumstance, and abuse of discretion. As Justice Walsh pointed out, this is viewed under an abuse of discretion standard. Nowhere has, as the appellant pointed out, errors of law that are clearly erroneous. They are merely just a weighing of the court of the testimony. There were 3 hearings in his where there were 4 witnesses, not just the mother and the father, but 1 witness for each, one of them being the preschool head of the father who testified, and also a neighbor of the mother who testified on her behalf.
Didn't the court make explicit findings that father was invested in the child, that father clearly loves the child and is a part of the child's life?
Oh, yes.
This order is not a comment on whether or not dad is a good dad at all.
No, if anything, I believe, and I'm trying to, there's an exact quote where he says it's clear that both parents love the child and are doing the best for it. Acknowledges that the father helps to coach him t-ball, child in t-ball, soccer and basketball, enrolls them in activities. So there's no question both parents are actively trying to be involved. This is just a question of pure distance. One lives in Gloucester, one lives in Amesbury. It's an hour commute. And for the school year, to make sure that for the best interest of the child are met, the court had to decide which was best. I would also sorry, go ahead. Oh, I would also take issue with one little fact that I know that there's a question of why the father didn't know what elementary school his child would be attending. I know that the father has stated that it was because of redistricting the court, but if on the point in that favor, I was trying to find the exact one, all the court found is that the father didn't know what elementary school. It didn't credit.
No fault of his own.
Right, through no fault of his own. Doesn't credit or blame him for not knowing, but doesn't say it's because of redistricting. So that's just.
To the extent that there was any underlying tone that the father said he didn't know where the child was going, it would be impossible to know where the child was going.
Of course. And so the material change of circumstances is obvious. Child's attending kindergarten. The father has to use third-party members in daycare because he's working full-time. And he does admit he's working overtime, and sometimes he doesn't know where he's going to be. He works for an electric company. It could be all around Gloucester. It could be outside of Gloucester at times, although he claims that he mostly works in Gloucester. It's the best interest, obviously, to attend the same school. The mother would be home. The school is within 10 minutes of her home, I believe it's stated in the record, and her work is within 10 minutes of where she's working. She's going to take mother's hours, up to 25 hours a week. The court credited that testimony. And there's no abuse of discretion on that. The second, on any of those questions of fact, there's no abuse of discretion or clearly erroneous. Second, in the application of the law to facts, and I point this out in my brief, the judge pointed out at point 28 that he has every right to modify the agreement. That's the statute. But in their brief, the appellant raises the point that of claim preclusion, implying that the previous judgments could not be disturbed. I would point out that statute and say, no, the statute is very clear, and the court makes very clear at point 28 of its findings of fact that is the basis, and we agree that is the basis. And so, and that is never addressed in the brief. Finally, in terms of arguing that this is arbitrary and capricious, there are 147 findings of fact here. The court had 3 days of hearings, again, 4 witnesses, very meticulous, 16 pages. This is not, you know, even on first blush, anything that would be credited as arbitrary and capricious. But the court seriously put a lot of thought into both parents' abilities to be there for the child during the school year, where the child will go to school, who could be there in case of emergencies. And of course, the child did have documented medical issues. I know that there was just a question about that, but those are documented. That's never been, you know, opposed and said, no, these are all fake, these are real medical issues. And so the child, if it does have that, is going to need someone who is there who could properly go to school. The father works overtime, he admitted that. It's not about punishing him. This is about the best interest of the child. And the father, I will point out, in his own modification complaint, was asking for full custody. So he was asking for exactly what he complains that the mother now has, which is the custody during the school year. Unfortunately, this is a Solomon's baby type situation. And in my opinion, and in my argument, the probate court made the decision based on a multitude of factors, a myriad of factors. And I believe that there's no abuse of discretion here on that.
Matter stands submitted.
Thank you, Your Honor. The rest of my brief.
Thank you both. The final matter on our docket this morning is 25P0026, Edward Wright versus the Massachusetts Department of Correction.
If it pleases the court, may I proceed?
Good morning, Mr. Wright. You certainly may.
Good morning to you, Your Honors. First, let me say it's a pleasure to be standing here before you. I spent 41 years in prison for a murder I didn't commit. I was recently released and exonerated, so it's a pleasure to be here.
Thank you, kind.
First of all, what this case is, you know the particulars of this case, I believe. The claim preclusion, claim splitting, neither one applies in this case. As the defendants feel as a matter of law.
I'm going to ask you to pick up, you sent us a letter telling us that the matter wasn't moot. There was some suggestion that perhaps this matter is moot. So can you start there?
The 16L letter? You didn't receive my reply to their 16L letter either?
We got a letter saying that
There's
this
two
matter
of
was
them.
not, oh, I don't know if I got the second one. But we
He
got
filed
one.
two, I filed two, replied to them. Their first 16L letter was that we were moot because I was released from the Department of Corrections. That has no bearing on the case, whatever, because the declaratory judgment went to telling the Department of Corrections to give me the illegal seized mail that they held. It doesn't matter whether I'm in their custody or not. They're holding my illegally seized mail to return
Is
it.
it fair to say that the governing law has changed from when they initially took your mail till today?
On the mail situation?
On the mail situation at the DOC?
Oh, you mean they
After
produced a
they promulgated
new
the new-
regulation? Yes, they
Yeah.
produced a new regulation, but that was after the fact.
Okay.
And that's the crux.
And as we're here today, do you have all of your mail back?
No. This is the issue that happened. After I was released from prison, I went back called to the prison, told them I was coming to get my mail, my property that was there. They said, okay, we'll have it for you out front, come get it. I went up there, they gave me part of the mail, says, oh, we didn't bring the rest of it out because we made an error, we'll send it to you. Same thing with some of my property. I've received neither. I've been out 4 months.
How much of it is missing?
There's probably 6 months worth of mail.
6 months?
About 6 months worth of mail. They didn't have it all, they only had part of it. The rest of it was inside the prison. And the mail guy that gave me the mail, he said that he would send it to me because it was his fault. He should have had it out there. I made the call. The property was supposed
Now,
to
these
be
are
there.
the original mail items, right? So they gave you photocopies of the items and retained the originals? Is that
Yes.
correct? And you're seeking return of the original mail
Yes.
items, and you're saying 6 months of the mail items have not
They
been
still
returned?
have at least 6 months of the mail, yes, correct.
When we talk about the world of mail, right?
Snail mail. Handwritten letters, type letters,
No,
pictures.
no, it's important. I'm not devaluing, but how much did they give you?
A good amount. Probably a box about this big, like this full.
And so is it a certain period of time, or is it certain type of mail? Because,
Well-
you know, you're saying, oh, like 6 months worth of mail that I didn't get back.
Yes.
So,
So what they did was, from April through probably November of 2021, that mail I don't have. They haven't given me from that point on forward. That's the mail that they gave me. The rest of it they haven't given to me. That mail is still sitting there at the prison.
And when you say they haven't given it to you, did they not give it to you in any form, photocopy or the original, or just not the original?
They gave me the photocopies back in 2021, going into 2022. The issue with the mail was simply this. They couldn't seize the mail because the regulation at the time was the 2017 regulation. That's still the same regulation when this mail was seized. They're saying we produced the regulation in 2022, so that negates what happened. It doesn't. If you read the appeals courts from the unpublished decision, they told them, listen, you have to abide by the regulation at the time the mail was seized. So they're saying, well, we made a boo-boo in 2021 when we tried to publish a regulation, and we didn't publish it correctly, so it wasn't promulgated. So that mail still, and that's the mail we're after. But it wasn't just a boo-boo, Your Honor. This was a tactical thing that they did up to prison. In April of 2022, I came before the appeals court. They gave me a decision telling them, any mail that you seized has to be done according to the regulation that was in effect at the time. So from April of 2022 through July, they kept seizing the mail, even though they knew they couldn't. And they just kept seizing it anyway. So then they said they ran back to the court and got the court to extend a defunct stay. The stay ended.
A couple of stays.
Huh?
They applied for a series of stays, but go ahead.
Yeah, well, no, they got one stay 180 days, and then they got it for another 60 days. And that ended on April 21st, 2021. That's why the mail comes after that. So the stay ended, the injunction was supposed to kick in. The injunction didn't kick in because we're on appeal. When the appeal ended in April 2022, they continued to seize the mail. Now they know that the court tells them, listen, your regulation is no good because you didn't promulgate it correctly. They still continue to seize the mail. So now they wait until 2022, in November, December, promulgate a third regulation. That one goes through. They said, hey, we're not giving you mail because we promulgated this regulation. The problem with that is the same thing the appeals court told them back in 2021. The new regulation doesn't apply retroactively. You put nothing in that regulation to apply retroactively, so the mail that was seized is still under 2017, which
So
is you couldn't seize it, you had to return it.
The mail that they have returned to you, the originals,
Yes.
would you say that's over half of the mail that was retained, or is it, can you put a percentage on it?
It was probably about 6 months of it.
6 months
Yes.
that they gave to you, and then they're still with,
And there's still first 6 months are still sitting there.
and have you had any more communications with them about
I
getting your mail back?
talked to the superintendent, called the superintendent, talked to his office, talked to the property officer, and that's as far as God. They always said, we'll call you back. Heard nothing.
So again, would you say it's 50% of the mail you never got?
Yeah, half-
25% you never got?
Yeah, half of the mail.
About 50%?
Half of that mail. All the other mail forward they gave me. It's just that mail.
Half of that that period.
That time period.
And you said that contained pictures as well?
That contains pictures as well. And that was my whole argument behind the mail regulation, was because of the photos. They were photocopying them on paper, and what happens with paper, when the officers come in and shake your cell down, they crumble the paper, the pictures are no good.
So what remedy, just out of curiosity, are you seeking? So
First, to declare the rights that the Department of Correction has to abide by the regulations at the effect that they're done. And the second is the injunction to force them to give me the mail back. Even though I'm released from custody, they still have my mail. Order them to give the mail back. This should go back to the trial court, to the judge that made that was a bad call on her part, in order to call it was claim splitting when it's not claim splitting.
So at bottom, you're seeking return of the mail that they still have.
Yes.
Now, if they're willing to return the mail, if you get the rest of it,
If they give me the rest of the mail, there's no need for the injunction. But if they don't give me the mail, I mean, I'm trying to force them to do something that they should have done. I mean, this went through
I
the
understand,
courts. We've been in front of the courts. They know they can't do it, and they continue to do it. I get released, and they're like, here's part of your mail, but we're going to keep the rest of it.
but I don't know, it seems like they're willing to give the mail to you. or they
Well,
gave
I
you some
thought
of
so
it,
when I
right?
went to go get it, and I drove all the way out to MCI Norfolk to get it from Medford, and they had advance notice that I was coming. So, they're
that
declaring
they-
the issue as moot. I don't find mootness.
I thought that they were representing or under the belief that they had returned to you all of the mail.
No. When I went to the prison, the mail officer who gave me the mail, he's the one that told me. Before I even went through it, he told me, he says, listen, it's my fault. The other mail's inside along with your property. I forgot to get it. He says, listen, because of what was going on at the prison, he says, I'll send it to you. And they were going to, at their expense, not my expense, at their expense. Never sent it. Called back to the prison, got nothing.
So, having had experience working with the DOC for a number of years, I can see where, an individual prison superintendent says one thing, right? And then there's perhaps no follow-through. But the department, so first of all, nobody's ever said, you can't have this mail. They just haven't given it to you, correct?
What, at this point? Since I've been released?
Yeah. Has
Well,
anybody-
they haven't said, but it's obvious when they haven't sent me the mail, and it's just sitting there.
And I'm just trying to figure out, and I'll ask the Department of Corrections is probably the right, generally speaking, when someone leaves, they don't want their stuff.
Well-
Right? So I'm trying to understand.
I would say this to you, Your Honor. I'm different than most prisoners. I litigated through most of my years in prison, the 41 years I spent in prison. I've been before this court several times on Zoom. I've been in the Suffolk Superior Court. I've been in the SJC briefing, different cases against the Department of Corrections for various, illegalities that they do. I'm constantly in the court with them. So, yeah, I mean, I think with me, I think that was an issue. So, you're leaving, you're gone, but here's part of your mail, but we're not going to give you the rest of it. And that's just the way that I see it. It may not be that may not be the case, but that's the way it appears to me.
Okay. So with respect to whether or not you're a litigious person, so to speak, is Right 3 still alive?
Right 3 is not. I filed it initially, but I wasn't the one representing it. Attorney Josh O'Neill was the one that was representing that. As far as I know, he got an adverse decision, and I don't know whether he's appealed it. I don't know what he's done. I haven't been in contact with him. So that Right 3 wasn't me. That's a class action. And again, that's why it doesn't apply to this case, because under a class action, I can't bring independent claims in a class action. That was a class action for the class. All those claims were for the class. They had
Right
nothing to do with
3 is the case seeking damages for photocopying, for not giving originals of the mail and
Yes,
only
for
put it
specific
between
period.
April 2021 and July 2022. And you're
Yes.
saying that was a class action?
That was a class action.
And it's
yes.
gone to judgment in the Superior Court?
It's gone to yes. And whether they've appealed it, I do not know. It was a class action because the Department of Corrections knew when they did the regulation, when they put the regulation out in April 2021, April 22nd, 2021, they knew that they hadn't followed the law. The law was give us 20 days, at least 21 days notice prior to a public hearing. They waited 9 days before it. They withheld certain information from the inmates so they couldn't give it to the people and have them go online to order to be there to cast their vote, to make their opinions known. So they intentionally did that. And then when I took them to court, they were like, well, no, we can do that. Well, you've been doing it for 41 years. We've been promulgating regulations for 41 years. You know, the Secretary of State gives you a handbook, a manual, that tells you 21 days. Why do you think you can do 9 days before the hearing?
Right 3 has counsel.
Right 3 has counsel, Josh O'Neill.
And
You were a
it's
party.
reached judgment, and so it's too late to add a party to that case, defendant to that case.
Yes. Yes. And, you know, for me, requesting a declaratory judgment for return of mail would have been inappropriate in that case. And, you know, the funny part about it was, had I done that and asked for it, we'd have still been standing here right now, and they'd have been saying, oh, no, he should have filed a separate suit. Because you can't ask for independent claims in a class action. It's for the class, not for the individual. And one other thing, you know, what the judge did in this case with making a ruling that she made on claim splitting, she threw 7 cases out there, and she doesn't tell you which one it is. They pick one, and this is a class action, which, again, the defendants are not the same defendants in this case. This is the Department of Correction. Those are individual defendants. They're sued in their individual capacity. The Department of Correction is sued as official capacity. They're persons. The Department of Corrections is an agency. They're not privy with each other. They're not the same defendants.
You could have added them as a defendant, right?
Could add Department of Correction?
Yeah.
Not in the class action, because it's for damages. You can't sue the Department of Correction. It's an agency.
Can I ask you, so this case was filed, you filed it in January of 2023, is that right?
Yes.
And wasn't Right 3 filed afterwards in
No,
February?
Right 3 was filed first, and then this case was filed second. Because that's a class
I have
action.
it as, I thought Right 3 was filed in February of 2023, but maybe I have that right.
And this one was filed 2 months after that. One was filed in January, this one was filed 1 or 2 months after that. Right 3 came first. This is Right 4.
Okay.
That's the name that they're giving it, Right 4. But they're, as I said, even so, by being a class action, I couldn't raise independent claims for declaratory judgment for return of my property only. The other inmates couldn't ask for return of their property because I'm the only one under court, basically, not a court order. They agreed to hold my mail. Everybody else's mail was destroyed after 30 days. And that's why they were suing for damages, because they couldn't get their mail back. They couldn't get their letters back. They couldn't get their pictures back. So that's how we ended up here right now. So unless you have any other questions, Your Honor, I'm done.
Hearing none?
Thank you.
Thank you. Very well argued. Attorney Bailey.
Good afternoon, Your Honors. May it please the court. My name is Yasmin Bailey, and I'm appearing on behalf of Massachusetts Department of Correction.
So we got a representation that all of his mail had been returned to him and that matter was moot. Has all of his mail been returned to him?
Yes, Your Honor, we stand on that position that all of his mail has been returned to him. Well, just to start with some of the things that he has mentioned with regards to his mail and the chaos in terms of his return.
Before we get to that, let's start with all of his mail has been returned to him. So
yes.
So how do we know that?
We returned it. That we provided him with about 4 or 5 boxes of his items to him when he came to pick it up.
Do you guys keep an inventory of what mails you've returned in a matter such as this? I don't know that you do this for everything.
Typically, we do keep an inventory of stuff. We don't keep, so regardless of whether or not he were to sign a form that basically says that we have handed over your property and we have handed over your items, sign off here. We do not specifically itemize in terms of, okay, this particular mail, which was scanned and copied on this particular date is being returned to you, and on this specific date, and et cetera, et cetera. We don't go into the specificities and the details as to each and every single particular mail or item that we are providing, handing over to you. However, we do not, in our property rooms, have any of his items in our possession.
That's a different question.
Sure.
Whether you have it or what doesn't necessarily mean that he has it, right?
Sure.
Even if you don't have it, doesn't necessarily mean that he has it. So in this instance, in a matter such as this, Did he acknowledge in writing that he received all of his mail? I heard you. Did you say that you have some acknowledgement that sometimes they acknowledge that on this date we're returning your mail to you and they sign off on it?
Your Honor, no, not that we have, Your Honor, that he has signed off on anything. That would be an error on our part, but when we submitted the initial 16L letter stating that we are not in possession of his items because he came to pick it up, that is what we were relying on because we did hand over his items. Whether he did sign off on something, no, we do not have
What
documentation.
if even in good faith, and
Sure.
that you've looked and you can't find it, but let's just say it wasn't given. Isn't that a triable issue? I mean, so this case was dismissed.
Sure.
And Mr. Wright saying, I got photocopies of everything, and there's this chunk of originals that were not given to me.
Sure.
You say, we gave it. He says, you didn't. Whether it exists still is a separate issue. But isn't that something that's worthy of continuing on to make a determination based upon who a judge or a jury believes is telling the truth?
And Your Honor, that's fair, but we're not holding his items hostage. As you mentioned earlier, we don't want his items. We like to give people, our incarcerated individuals, their items once they are no longer in our custody. There's no reason for us to have it.
There seems to be a dispute that we can't resolve
Absolutely.
based on what we have before us, right? That would have to be something that's resolved in the trial court with some evidence.
Sure, and that's absolutely fine, but I don't think.
Can I just,
Sure.
am I hearing correctly, is the Department of Corrections agreeing that this case needs to be reversed and remanded for findings?
I don't, because we don't believe that there is a live controversy, and I think there's mootness on independent grounds with regards to the regulation itself being superseded.
Let's leave aside.
He's no longer in our
Leave aside
custody.
the regulations
Sure.
for a moment, okay? Judge Connolly said that he could have brought these claims in Right 3.
Sure.
Could he have? Right 3 is not, he's not the lawyer in Right 3.
I think how Mr. Wright has explained Right 3 was a bit misleading. When the case was initially filed, and Justice Shin, you were correct, that Right 3 was actually
That's what I
filed
thought.
first.
So does prior pending action not literally mean prior? So Right 4 is prior to Right 3.
Your Honor, that's correct, but if you look to Wright Machine Corp. versus Stephen Andwell Corp., the court recognizes the general rule that when two different actions involving the same parties and same claims are pending at the same time, final judgment first rendered is entitled to res judicata. And here
There
in
was
this
no
particular
final judgment entered in Right 3 at the time
when
Judge Connolly dismissed this case.
I understand that, but in that particular situation, when the case was brought before the Right 4 trial court, the judge was allowed to take judicial notice of cases that were in existence on the docket.
It was
These are
pending,
publicly
but it
available.
wasn't a prior pending. It was just pending, right?
You are correct, Your
Okay.
Honor.
So it's not a class action?
Initially, when it was filed, it was not classified as a class action. That was an argument that was made by our attorneys that in the case of where there are multiple pro se litigants, there must be an attorney that is representing, and this should be an actual class action itself. So initially, it was not considered a class action in its
Was it
original
certified
form.
eventually as a class action?
As far as I'm concerned, that's not clear, and I know they do have a hearing, a motion 12 hearing that is scheduled, from my understanding, next week.
I thought Right 3 had gone to judgment. Is that not true?
That's not what I've heard.
Okay.
But the DOC moved that it be a class action.
Yes,
Did I just hear you correctly?
that there should be representation, and if they do have now representation, then, because remember, initially, there was a stay that was placed on Right 3 pending that decision that came down from the affirming of Right 2 from this court, which
And
was that.
in Right 2,
Yes.
a panel of this court said that agency officials sued in their personal capacity are not in privity with the agency. And that's what a panel of this court said in a case involving the same plaintiff. Are we just supposed to pretend that doesn't exist? I mean, Right 3 involves, as far as I know, a claim for damages against officials in their personal capacity. So how could he have brought his claims in that lawsuit?
Your Honor, the reason as to why we believe that Right 4 could have been brought into Right 3 is because at this present point, again, injunctive relief aside, because our position is that there's no injunctive relief to provide because we have provided him with his mail. The only thing left in this particular case is declaratory relief, and it's in his prayers of relief, he's requesting that the court declares that his constitutional rights have been violated, regardless of what.
That's a different question whether there's any relief that he can be granted. But the fact of the matter is, a panel said in Right 2 that there's no privity. So if there's no privity, there can be no claim splitting.
And Your Honor, while we respect that, we do respectfully also disagree that there is no privity between the Department of Corrections and their staff, because essentially
There is if they're sued in their official capacity, but not in their personal capacity, right?
Yes, you're correct, Your
Okay,
Honor.
so in Right 3, they were sued in their personal capacity. In this case, he's suing the department, or I don't know if he named the department or the officials in their official capacity, but those are not, regardless, there's no privity there.
Your Honor, we respectfully disagree on the grounds that the interest here is identical.
Did you seek further appellate review?
With regards to?
In Right 2.
In Right 2.
No, we did not seek
I mean,
further
Right
appellate
2,
review.
they went through a body of federal case law that supports the notion that there's no privity between official capacity claims and personal capacity claims. So, I mean, we have no argument from you that that was wrongly decided.
No, Your Honor, you do not have.
Okay, so if they're not in privity, I don't really see how this could be claim splitting.
Your Honor, respectfully, we disagree, and we hope that this court does determine that this is claim splitting, just strictly on the grounds that the ideas itself is the act of defending the DOC regulation itself. Because, I mean, the constitutional question that needs to be asked in both cases is whether or not the department violated his constitutional rights. That is happening in both cases, and that can be done in Right 3, because in order to get to the qualified immunity defense first, the court has to get to that question first of whether or not the actions of our officers were unconstitutional. So whether or not in this particular case, if you declare that, yes, the Department of Correction violated his constitutional rights, and meanwhile in Right 3, the court also decides, oh, wait, no, there was, the DOC did not violate the constitutional right. Now you have two separate decisions here where one court is saying one thing and one court is saying another thing when the question itself is essentially the same.
I get that, yeah.
If the man didn't get his mail back, is that a violation of his constitutional right? If he didn't get his mail, is that a violation of his constitutional right to receive his mail?
I mean, well, if we're looking strictly at Right 2 and the decision that was made there with regards to whether or not we violated his constitutional rights with the photocopy of incoming non-privileged mail, it's no. We did not violate his constitutional rights.
If he didn't get his mail back, is that a violation of his right? If he never got his mail, is that a violation of his right?
Sure, we have a question there of us violating his rights, but that is not what's present here. We do not have it.
The argument I'm hearing him say, I never received my mail
Sure.
for this window. And you're saying you did, so that seems to be a fact issue.
Your Honor, and that's correct, but if you decide today that we need to go back down to this, that there is an issue in terms of whether or not we still are in possession of his mail, the answer is still going to be no, and we can always submit an affidavit.
Well, that's something that would
saying-
have to be resolved by a trial judge, but I'm not even sure it's the same legal issue in the two cases. To get damages, which is what they're asking for in Right 3, they would have to show violation of constitutional right.
Correct,
under
and that would
1983.
have to
Okay.
happen here as
In
well.
this case, I don't see why. He's
But that's
saying,
one of his prayers of relief, Your Honor.
okay, but
Yes.
he's saying, from what I understand, maybe it's a constitutional violation, maybe not, but regardless, the regulation that was in place at the time this mail was withheld was not lawfully promulgated, and therefore you have to go back to the previous version of the regulation that did not authorize the withholding of the mail, and therefore it was a violation of the regulation. If he prevails on that, why doesn't he get his mail back?
Your Honor, just to answer the first part of your statement, the DOC was relying on a presumptively valid regulation, and until a court holds otherwise that there was an issue. A court did not hold that there was an issue with our regulation until that very moment in April of 2022, that there was administrative...
That goes to the merits. He's saying, though,
Yes.
that you say it was presumptively valid. He's saying it was not valid because it wasn't promulgated correctly, and therefore you go back to the previous version. That's a merits issue, but that's a different issue than what's being decided in Right 3. Because this issue would not entitle him to damages, right? If he prevails on that, he would only be entitled to equitable relief. So he doesn't have to prove a constitutional violation to get injunctive relief.
Yeah, but Your Honor, there's no injunctive relief to provide here because
I understand that that's your position, but I'm just, in terms of the claim splitting, it doesn't appear to me that it's even the same legal issue in the two cases.
Your Honor, and even if it were the case that we were to concede on whether or not it is claim splitting, we still stand on the position that this case in itself is moot. He is no longer subject to
Okay,
this.
we'll have the chance to do that.
Yeah.
I have one more question, which is, for dismissal under Rule 12b-9 for prior pending action, does prior literally mean prior?
I mean, in the textbook definition of the word prior, possibly, but with regards to Wright Machine Corp., again, there was a first judgment that was there, and there was judicial notice that was
You
taken.
would agree that Right 3 is not a prior action?
If we're looking at it from the textbook definition of the term prior, yes, you are correct, because Right 3 was filed first.
Okay, thank you.
Your Honor, if there are no...
Because Right 4 was filed first.
Yes, Right 4 was filed. Thank you.
Right.
Your Honor, if there are no further questions, I will rest on the brief.
Hearing none, the matter stands submitted. That concludes our business for the day. Thank you kindly. Court is in recess.